cantaloupes to consumers may well be left holding, the financial bag, so to speak, and be held liable simply because they sold a product that was contaminated from a manufacturer who has no assets.
Well, that really cuts a wide swath along the food chain from, and there's a coined phrase, from the farm to the fork. And in your litigative process, so you're saying that potentially liable parties are all of them.
It does, yes, in a broad way. That's true. It varies a little bit from state to state. There's some states that give a little bit more immunity to retailers than others. But the one sort of common denominator amongst all the states is even in situations where a retailer is relatively immune, if a manufacturer is, for example, overseas and the victim cannot get service on them, or the manufacturer or the shipper has insufficient assets to cover the damages, the retail outlet, will be held responsible, because as between the consumer and the retailer, shipper, grower, the law presumes that the victim has a right to be compensated, and that the retailer who sold it, the shipper who shipped it, the manufacturer who made it, bear that responsibility.
Very interesting, particularly with your emphasis on in the cases where the product comes from overseas, and what you mean is imported into the United States from another country.
Correct.
You'll find, I think this is a general statement, during the summer months, a lot of the produce is local, but some of the produce during the winter months is actually imported from quite a distance.
Absolutely. And, what it really does tell you is that, growers, in the United States who then may import products, during winter months, those shippers, those importers, and even those retail outlets, it really behooves them to pay a lot of attention to, the quality, of the growers, whether they're, inside the United States or outside. But from a, if something goes wrong perspective, having a solvent, entity, in the United States, or the ability to attach, by contract, the assets of a outside the United States party, becomes, critical, depending upon the size of the outbreak.
Outstanding. What I'd like to do now, Bill, is focus a little bit, you mentioned it earlier, on the basis of evidence which best supports bringing forth litigation to represent your client. Sure.
This is where most of the focus of what I do is in evaluating a claim to determine whether or not on a more likely than not basis. So that's the standard, that most times I can prove that the product that sickened my client was in fact that product. And there are a lot of tools to do that. And a few years ago I wrote a sort of a how-to manual. It's called Separating the Wheat from the Chaff. And I have it up on my blog at marlerblog.com. And it's a really, I think it's a pretty interesting sort of viewpoint of how to prove a foodborne illness case, but also how to disprove a foodborne illness case. In a sense, you could reverse engineer it. But primarily what we look at is, did the product cause the illness? And, if you focus at the listeria outbreak linked to cantaloupe, is there a positive listeria test result from the blood of the victim or the spinal cord fluid of the victim? And are they a match to the outbreak, and in this instance appears to be strains? That's really good evidence that there's a common denominator between a lot of people, and the common thing that they consumed was cantaloupe. The evidence gets better if you can find leftover cantaloupe, which they found in this instance, and then it gets even better if you find evidence of listeria in the packing equipment, which they did. So, the proof of causation that product from that farm and this shipper caused damage is pretty overwhelming in this listeria case. It gets more complex, and likely cases that I would never take would be cases where there was no positive culture, and you're trying to put together a case saying, I've got a receipt and I had, an illness. That becomes the type of case that it certainly is possible that they were sick, but if, it is my burden and my client's burden of proof to prove that in fact it did. And, as you start to unwind some of that scientific evidence, it becomes much more difficult to prove a case. So most of the time, probably about 80 to 90% of the cases that come to our office are cases that we review, and we send people, along the way, saying that it's not a case we could take because, in our view, it's not a case we can prove.
Outstanding. So 80 to 90% of the cases that are proposed to you by allegedly damaged clients may not have this best evidence to support your litigation. Is that correct?
Yes.
As we look at the types of tests the government runs, they run the culture, which is the inoculating the glass plate in a gel medium, or there's also the pulsed field gel electrophoresis, which is reported food net. Do you bring those experts in from the government as well?
Well, not from the government. The government tends to, certainly we use the data that's generated there. But what we do is we try to bring in, all the parts of the puzzle, the PFG, and certainly some of the, more recent uses of MILVA, and in addition, traceback records. Having a whole bunch of people throughout the United States that have the same PFG pattern of E. coli or Listeria doesn't really tell you what the product is. You really have to have, good product ID, which is very problematic in many instances, especially in Listeria cases, and I think in many respects why you don't hear a lot about Listeria as an outbreak in food as frequently as you hear it in Salmonella or E. coli, because the incubation period for Listeria is so broad, 3 to 70 days, and to try to ask a 80-year-old who's been hospitalized for a month and a half what they consumed 70 days ago certainly is creates an issue, and so many times it becomes a situation where you're not able to prove that case because you're trying to put together all the pieces of the puzzle, and when you have missing pieces, it makes your case sometimes virtually impossible to prove.
Well, that's a very interesting point that you bring up about traceback records. With the passage of the new Food Safety Modernization Act, one of the requirements is that these food producers perform mock recalls and that their records be in order and that they have certifications, whether they're foreign or domestic. Do you think that's going to help food producers and maybe yourself identify these cases more rapidly and accurately?
Well, I think in some respects, I've always